I have done protective orders, just so that y'all are like, who is this woman and what does she know? I have done them for our office. Who here has handled a divorce? Oh, basically everyone. Who here has handled a divorce and filed a protective order as part of it? Okay, still mostly everyone. Love that. Who here has handled a divorce with family violence and referred the protective order to my office? All right. I'm going to tell y'all why you shouldn't do that. Not only because it's more work for me, but as part of a protective order, as it seems like most of y'all have enough basis to know that a protective order carries criminal consequences. Accordingly, that makes it a pretty heavy tool in negotiating a divorce. If it goes through my office, it's a lot harder to use it in negotiating a settlement to your divorce. So I would encourage you very strongly, if you have one of those cases, to do the protective order as part of your case. It gives you more leverage in negotiating a settlement. If you're like, well, that's great, I don't know what a protective order looks like, shoot us a message, we'll send you forms. We are willing to help, you know, we're willing to kind of walk you through the process, but our attitude is if you can do holistic representation for your client, it's better for the client, it's better outcomes in terms of negotiating a settlement, and I'm not gonna lie, it is, you know, one fewer case for me. So win-win-win all around. Protective orders are pretty easy. So if part of why you refer them to us is you just don't want to deal with them, they're actually pretty easy. You have two kinds primarily, and I'm going to give you the quick overview and then we'll get into the nitty-gritty. The bulk of our protective orders are domestic violence, family violence. And those are under Chapter 85 of the Family Code. And to prove one of those up, you have to prove a relationship existed that meets the requirements. And then other than that, you just have to prove that family violence occurred and is likely to occur in the future. It's a pretty low burden of proof, pretty low standard. That's really all it is. For the other kind of protective orders, you have stalking, sexual assault, and harassment. You have to prove that there's a reasonable likelihood to believe that it happened. Again, real easy to prove up. So if you have one of these cases, and on those you don't have to prove likelihood of future harm. He can be sitting in jail for sexual assault for the next 10 years. And if you can prove up that it happened, and if he's in jail you probably can, well then you've got something that carries criminal consequences that you can use to get a protective order, or use as a bargaining chip in your divorce. So let's go into that a little bit more. So for a family violence protective order, you have to have a set type of relationship in order to qualify for one. For sexual assault, for obvious reasons, it can be no relationship. Sexual assault, harassment, stalking, you don't have to show a previous relationship. So this is a list of who can file for a PO. Sorry, I jumped ahead. So one thing that's interesting, I do a lot of CPS cases, if y'all have seen me there, and we can apply for our kids, if our kids are victims. DFPS can apply, any adult to protect a child. And a lot of times, if you're in custody disputes, that's what you have, is you have one party trying to protect their kids. So if you don't think you can prove that mom's likely to get rid of a kid, you can apply for someone else in the household. Stalking, harassment, sexual assault, minors if it's domestic violence. If you have a 16-year-old whose boyfriend beat them up, they can apply for a protective order. You don't have to be at the age of majority to do this, although a custodian can then petition to modify. Household or family member. So this is the definition of the Family Code of a household or family member. It's pretty broad. If you have lived with someone, if you have a child in common, if you have a foster relationship, if you share, it's broad. So typically the relationship, unless it's a stranger that beat you up on a first date, often that's not an issue. It's not something we spend a whole bunch of time litigating. But here's the list. And then also dating relationships. So if you don't meet that list, this list is pretty broad. And it's just anyone who's has had or has a continuing romantic or intimate relationship. And here's a bunch of factors the court can look at: the length, the nature, the frequency, the type. Again, if there's been any type of dating, living together, raising a family, it is very broad. I haven't had many cases where we get into a legal issue over does this meet the relationship? It's either like, no, clearly it doesn't, you've never been on a date with them, or you can fit it in somewhere. So the findings for a domestic violence protective order, the first two are one of the set relationships. And then what we just talked about, has engaged in family violence, and family violence is likely to occur again in the future. And that second prong, in my mind, is where the most litigation happens. You do sometimes have he said, she said over whether the initial incident happened. But in my mind, if you can't prove the initial incident, you're going to have a whole lot of trouble proving likelihood of future harm. So in terms of planning your trial strategy, I like to start with, can I prove there's actually a risk going forward? Because if not, that's kind of a harder case. So here's some more, here's the definition of family violence, and it's what you would expect, resulting in physical harm, bodily injury, assault, sexual assault, or, in this one, we filed under this. And people, I find that judges are less likely to grant one based just on threats, but it depends how bad the threats are. If it's one of those things where you can't afford to risk it, he's giving detailed threats of, I know how to get into your house and I'm going to come kill you, then that's family violence, if you have a reasonable likelihood to believe it. So, again, if it hasn't happened in the past, you may have trouble with that likelihood of future harm. But if he's blowing up your phone with detailed threats every day, then that's probably going to continue, and that's probably something that a reasonable person would be in fear of. So that's also important, because we have had it come in where it's escalating, nothing's happened, and someone will be like, oh, but you don't have family violence. If you have a bad enough threat, you can file under that. So then, if your victim is a child, the statute gets broader. It can be physical injury that results in harm to the child, or a real risk in resulting in substantial harm, using a controlled substance that results in the physical, mental, or emotional injury to a child, and it happens more than you would think. I mean, we have parents giving their kids drugs, we have parents who let their kids get into drugs. It sounds like something you wouldn't see, but you do. Encouraging children to use drugs, sexual conduct harmful to their well-being, which can include pornography. So if basically, you know, it's broad. So here we have the ones that are under the penal code. It's going to be chapter 7A of the penal code if you're looking at these. Again, you lose that likelihood of future harm. I can't tell you how many times I've talked to opposing counsel and they say, well, where's your likelihood of future harm? You don't need it if you're under the penal code. Sexual assault victims, other type of sexual offenses, stalking, trafficking, don't need a relationship, don't need likelihood of future harm. So again, the problem here, you don't have to worry about future harm, but these are harder to prove up than family violence a lot of times. Stalking. Here's the definition of stalking. If you ever have a stalking protective order, print the statute and highlight the provisions you want to use. Because if you look at this, there are a lot of ords in here. And judges don't grant many of these. I've filed maybe 2, and I've had 1 granted solely on stalking grounds. Because generally, you know, judges don't necessarily understand what the big deal is about them. So if you go in for a stalking or a harassment one, print out the statute and highlight the provisions that you are relying on. So that you can say, Judge, there's an or in this list. I'm highlighting the provision that I am relying on. That has worked wonders for me. Because if you stand up and you say, I'm going to show that he committed harassment or acted in a way that the stalking resolution knows threatening to the victim relationship, blah, 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 you lose the judge. Even a judge who's used to listening to legalese is going to be like, whoa, what? Print it out, print it for opposing counsel, give it to the judge. These are the particular parts I'm going to rely on. And these are hard ones to prove in my mind. You have to have pretty overwhelming stalking, and you need evidence. So the one that we did, I walked in with a binder of text messages. So a lot of people use the term protective order pretty broadly. An EPO or emergency protective order is granted when someone is arrested and booked into the jail. It can be done on sua sponte on behalf of the judge or magistrate. It can be done at the request of the victim. It can be done on the request of the prosecutor. A TexPro, a temporary ex parte protective order, is done if you are in immediate danger and you're going to the judge and saying, Judge, I don't have time to wait to serve this guy and get him into court and find space on your docket. My victim might be dead or at least beat up again. We need this protective order now. And that's what that is. And then you have your permanent or final protective order. So EPOs, I just talked about this a little bit. There's the Code of Criminal Procedure, statutes, and these are also ex parte. So it can be done at bequest. I talked about that a little bit. That's kind of an important part in my mind, is all the people that can ask for it. They're usually only good 31 or 60 days, and there are conditions where it's mandatory for them to be issued. Temporary protective orders. So the TexPro, again, these are good for a maximum of 20 days. These are the ones where you come in and say, Judge, I'm fearful now. I need your help now. And again, if you're doing a divorce and you can prove up a temporary ex parte protective order, that gives you a lot of leverage if all of a sudden they were having access to the house, the kids, the property, and all of a sudden there's a TexPro in place. Then all of a sudden you're bringing them to the table a lot faster. It can be extended for a maximum of another 20 days or by agreement, and that's to give them time to come into court and prove up the final, contest the final, and get their day in court. Kick-out orders are very fun. If the domestic violence has happened very recently, you can kick them out of the house. So if the DV has happened between two people that live together in the last 30 days, and you can show that likelihood of future harm and the imminence required for a temporary ex parte, you can also get a kick-out order. And the constable will go to the house and stand there and kick the offender out. So there are a little more requirements. You have to have jointly owned or leased. So if it is the abuser's house, sorry, you can't kick him out of his own house. But if it's jointly owned, then yeah, you can kick him out and say, we need to get in before a court, because I'm not going to have you beating me up in the middle of the night. One thing that people often forget is your victim has to appear in person to get an ex parte kick-out order. Our judges very rarely ask for in-person testimony, but the code requires that if you're going to ask to kick someone out of your house, your client has to be there to say, yes, this is true, I'm not making this up. And that's because it's an extraordinary remedy, right? To be able to go before a judge and kick someone out of their home without as much due process. So you need the sworn affidavit that you need for all TexPros, and then you also need your person at the courthouse in case the judge has questions. And again, for these TexPros, this clear and present danger is a heightened standard. It's not just reason to believe that it occurred and will occur again. There has to be a clear and present danger. So you do have to make sure that you can show a little bit more if you're going to ask for a kick-out order or a TexPro.
Can I ask a quick question? Isn't an EPO a 30-day kick-out? I mean, you could use that as a kick-out too.
So great question. If you get a protective order against yourself, in a way that can be a kick-out, right? Because if you can't be X number of feet from me, we had a case where I was filing a sexual assault of a child protective order against a neighbor. And the neighbor was an adult. We had a 16-year-old with mental illness who had been sexually abused. So I just filed for a normal protective order. And guess what? They were close enough that kicked him out of his house. And I did not have to meet the requirements of a kick-out order because I wasn't getting a constable to tell him to get out of there. But if your person isn't in the home and they have possession of the home, you probably want a constable to go tell him he can't be there. So what this does is the constable will drive to the house and say, you need to pack a bag and get out right now.
So I've had one that was an EPO, so there was assault family violence. It was his house, but it was a marital residence. Even though the guy owned it. He was arrested that night, 30-day EPO. And we did get an extension on the kick-out, even though it was his house, because it was a marital residence, no kids in it.
So I don't do as many EPOs because I don't do a lot of criminal law, but I would believe that would work. I have also seen seen people kicked out of their house by an EPO. I don't ever file for them since I only do civil, but I have seen people kicked out on behalf of an EPO. So if you can get, my guess would be that if you're the divorce attorney, you're not the one asking for the EPO on the scene.
They come to us.
But if it happens on its own, then absolutely. Yeah. And like I said, when we got one, we didn't file for a kick out when we got this guy kicked out of his house because it was too close to her house. And the constable called us and said, you realize the result of this is he has to leave his house. And we said, yes, we do. You know, it's up to him if he wants to violate that protective order or not. So this is for final protective orders. For a final protective order, unlike the temporary ones, you're going to come have a full-blown evidentiary hearing. So rules of evidence apply. The other party can put on witnesses to rebut it and say she's lying to get leverage in her divorce, she's never been hit in her life, she was the primary aggressor, whatever the defense says. New as of this past legislative session, final protective orders can go up to a lifetime if the abuse would have been a felony. So you get a deadly weapon, you get recurring DV. So if they've already had 2 DV convictions and you can show another one, well, that would be a felony. You can apply for a lifetime. Realistically speaking, it's got to be pretty bad for judges to want to issue a lifetime protective order. Because not only does a protective order carry criminal consequences if you violate it, it also comes up on criminal background checks, and it also means you have to surrender your firearms. So there are very real consequences to having a final protective order against you. But if you can do it, you can get a lifetime. There are also some other provisions down here that people aren't as aware of. If someone's in jail and that protective order expires solely because they were incarcerated, it can get extended because the law recognizes that he may not be violating because he's in jail and not because he's stopped being abusive and stopped being a threat. So that's a good tool if your client is saying, well, yeah, he's not going to violate for the next 2 years, but I'm real worried when he gets out of jail and blames me for it. So it's just a good thing to know. We talked about these a little bit. These are some special rules. You have to turn over your weapons. If you're incarcerated, it can automatically be extended upon release. Jurisdiction's a good one. Jurisdiction's pretty broad. You can file where the victim lives, where the applicant lives, where the respondent lives, or where domestic violence occurred. If there is a divorce, you really should file it there. You can also file it where the victim lives and file notice into the divorce, but it's better practice to file where the divorce is pending. And then children's information and victims' contact information, I'm CPS primarily, so my terminology is all wrong, can be kept confidential. All right, so I'm sure this is a little bit, I'm sure y'all know this, but it's fun. This is the stuff you can bring in as evidence. 911 tapes are great. A lot of ways to get around hearsay, present sense impression. Sometimes you can even get party opponent, there's a lot of things. Pictures are great, better than testimony about it. Child witnesses, I'd be very cautious with that one. Judges are really skeptical of dragging kids into court. If it's your only way around it though, they're also very, very understanding of kids, but do make sure you really need that evidence before you bring a child to court because judges don't like that. Or file something for alternative testimony. The Family Code has a lot of provisions for taking alternate testimony of children. A great one is if the child calls 911. The Family Code has an exception to hearsay for outcries of abuse. And it doesn't have to be the outcry witness like in criminal where it's first person. It's just any statements by a child under 12 about child abuse. Now, if mommy's getting hit, is that child abuse? Yes. The law is very clear that children witnessing domestic violence counts as abuse because it does so much trauma to them. So if you've got the child calling 911, ooh, not hearsay, play it all day long. Neighbor witnesses are also good. Oftentimes, if it's been a recurring pattern of violence, oh, they've seen the fights, they've heard the fights, that goes to likelihood of future harm. If a neighbor is saying, oh, all night, every night, they're yelling and screaming and banging on doors, absolutely. Officer testimony, love bringing in officers who make calls of service to the house. They're usually pretty good witnesses because they testify fairly often, and if they can say, like, I know this house, I'm there 2 times a week, that's great evidence. Notes, cards, letters, we have some more information on that. Digital communication is my favorite. You would not believe what people put into text messages. You're all often going to get things that say, baby, I'm so sorry, will you ever forgive me? What are you sorry for, sir? It's a statement by a party opponent, so it's not hearsay. I guarantee that your client can authenticate who it's from. Is this a screen name that you've received messages from in the past? Do you know that it is him? How do you know that? And that stuff is good. If they will bring you phone dumps, you're going to get some good information. Physical evidence, torn clothes, busted windows, broken doors. I have fewer of that than the other, but if you have it, it's good evidence. Make sure you know if there are weapons in the house, because it really helps in terms of showing likelihood of future harm. CPS investigations. I do primarily CPS work. We document everything. If you have a case that's going to be contentious and you have time to do thorough discovery, subpoena CPS records. Sometimes our investigations close without a custody case and say things like, Dad is crazy, but Mom is very protective. You want that. You want it for the divorce, you want it for the protective order. I mean, it is a fountain of information. Yes, sir.
Are there any punishments for filing for false testimony for protection orders?
Not that I know of. I think you can probably file for attorney's fees for bringing a frivolous suit. If it's through my office, we do ask for attorney's fees, but they're pretty nominal. If it's really bad, you can file for perjury because you have to file a sworn affidavit stating to the facts. So the biggest one I would think would be perjury. If you get someone perjuring themselves and you can prove it, refer that to law enforcement for perjury charges. Good question. 911 tapes. We talked about this. Excited utterances, background noises. Talked about children calling in. It happens more than you would think, and that is gold. Then you get the benefit of the child's testimony without having to look like the jerk that pulled a child into court. Even on a hang-up call, you might hear something. Pictures. The suspect, everyone thinks of pictures of the victims, but sometimes you get people looking very threatening on the scene. So look into that. Police report. Police reports are gold because they're trained to take in detailed notes. So that's one. And stuff like that is good if there weren't charges. If your client filed an affidavit of non-prosecution and now you're going, you want me to file for a protective order? If you bring in a picture like this and you say, so why'd you file that affidavit of non-prosecution? A lot of times they have a pretty good answer. And you want to know what that answer is before you put them on the stand and ask that. But often the answer is, we were still living together at the time and I thought he would kill me if I didn't. People understand that. So pictures are good because it illustrates why there may not have been a criminal trial, why they may not have been the most cooperative victim the first time around. Follow-up pictures is a big one. So everyone thinks of the pictures on the scene, but I mean everyone here has had a bruise. They turn really impressive colors 1 or 2 days later. So if you're getting the person calling you soon enough, tell them to take a picture the next day or 2 days later. It's not just the on-the-scene pictures. Sometimes you want to wait a little bit. So this is just, don't forget about kids. Like I said, I'd be very hesitant to bring a child in as a witness, but it's worth telling the judge, you know, ma'am, were your children present for this? How old are they? How much of this have they seen? How much of this have they heard? What have they ever said to you about this? Because again, statements by children under the family code are not hearsay if it's about abuse. So if you can get going back to CPS records, if you have a CPS investigator that you can put on the stand and she says, you know, little Susie says that daddy gets drunk and hits mommy all the time, if that's a 4-year-old, I've had a 4-year-old say, I tell them to stop and take a breath. And that's heartbreaking to have a 4-year-old who feels like she has to say, daddy, just breathe, it's gonna be okay. So ask about the kids. Even if you don't want them as a witness, you may want to know what they know. Often, law enforcement is starting to take children for advocacy center interviews if they've witnessed domestic violence for the exact reason I'm saying. So if there's a law enforcement investigation, ask about that. Did you interview the child? Did you take them to the advocacy center? Because what that means is you may not have to interview the child. A professional may have already done it for you. Text, cards, social media, etc. They exist in every single case except maybe a stranger sexual assault. There is something in social media or in writing. Whether it helps you or hurts you, I can't say, but there is going to be stuff. We have had cases that we have non-suited and gotten out of when we said, hey, bring us all the text messages, and they substantiate his side of the story. So look at them, ask for them. There's a lot of times that it says, I'm so sorry, please take me back, will you ever forgive me, it'll never happen again. You get all of that stuff. Yeah, so Hallmark cards, Facebook posts, Instagram calls are now a thing. I've had someone bring me call logs that were I don't know, but you can get it, all of that stuff. Whatever they use, there's going to be something on there. So this is a real example from one of Elizabeth's cases. She did this PowerPoint, but these are rules that a respondent had set forth in a letter to the applicant. And it's, I need to know about your day every day. I need you to show interest and know about all of my days. I need you to tell me every day that you love me. I need you to show me appreciation for my efforts in financially supporting you. I need you to acknowledge the fact that we have a dog and try to enjoy and interact with him. I need you to understand that I need time alone each week, 6 to 8 hours. I need a massage 1 hour from you once a week. I need you to take responsibility for cleaning the house. I need you to allow me to complete my sentence when speaking to you before you begin to speak to me. I need you to maintain your body weight between 100 and 110 pounds. I prefer you at 106 or less. I need you to cook an Indian meal at least once every 2 weeks. You must wear your wedding ring at all times on the correct finger. I will also wear mine when you get me one with money you earned. Do not blame me for the things that happen to you in your life. Life is the result of choices we make in our lives. I do not want to have any more children. If you choose to remain married to me, you have no right to hold me responsible for any regret you may have if you develop the desire to have children while married with me. You must never hold me accountable for any lack of communication in our lives. Love, David. So, this doesn't show violence, but it shows a pattern of controlling behavior. And most of our judges, this is not going to be their first protective order. They're going to read this and go, oh, wow. So stuff like this, it's great. Ask your client, has he sent you letters? Has he sent you cards? Does he text message you? Because you want to see that. Physical evidence. So we just talked about this. It's harder to get, but this is a really good example. You can put a witness on a stand and say, what'd you look like afterwards? Oh, there was blood on my shirt. Or you can do this. It's not the same effects. When you're talking to your client and you're trying to get witnesses, who have you talked about? Because, you see this all the time where the response is, you're just saying this to get a leg up in a divorce. And like I said, it doesn't help you to get a leg up in the divorce. But ask them, who have you told about this? When did you tell them? How long before you filed for divorce did you tell them that? Is it bolstering? Kind of. But if they get on the stand and say you're just making this up now to get a hand up in divorce, and you can bring in her mom who said she called me 5 years ago about the first incident, I mean, that's pretty good. Has anyone ever seen it? How can we reach you in 6 weeks? Who will know where you are? A thing I would add to how can we reach you in 6 weeks Is he monitoring your phone? Is it safe for us to reach you by phone? A lot of times we assume that by the time they've come to a lawyer, it's open season on that. But make sure you know. And especially if they're coming to us just for a protective order, sometimes it's not. Sometimes we are their one hope to get away. And you really do have to ask, how can I reach you? What should I title my email? You know, it can be rough. So don't assume it's safe to call. Forfeiture by wrongdoing. Oh, we see this all the time in domestic violence cases. If you have a domestic violence divorce or protective order, are there a bunch of cases that were dismissed and affidavits of non-cross filed? If so, if you ask the right questions, you're going to find forfeiture by wrongdoing. You're going to find that these people who are controlling and entitled and beat up their spouses for years, they're likely saying, if you testify to that, I'm going to kill your dog. If you testify to that, I'm going to take the kids and you're never going to see them. A lot of times it's also a statement by a party opponent, so it may not be necessary, but it's worth considering. Do you have a forfeiture by wrongdoing? If so, does that open up otherwise unadmissible evidence to you? All right, and that is what I have. That's my name. I am not the Family Justice Chief. I am just a Family Justice Indian. But I have cards if anyone ever has questions or comments, and if you have questions now, yes ma'am.
So used to, we would send people to the county attorney's office to go get a protective order when they came to us for a divorce if there was domestic violence. Or maybe they didn't have the resources for the attorney to go do both. Now you guys are kind of pushing them back to the civil attorneys. Who's a good candidate to come in and get a protective order from y'all?
Great question. So if they don't have the resources and we're their only options, do send them to us. But my point is that it often will help your case to do it. You'll get evidence that will be just as applicable in the divorce. It'll leverage onto your divorce, and you can file it into the divorce. The other thing that I find that y'all may or may not be aware of as private attorneys is judges hate to rule on protective orders when there's an open SAPSER. Unless the child has been hurt, I'm not getting a child in protective order. If you file it into your divorce and do it as part of your temporary orders, that concern goes away. So what judges are telling me, and it's not in the code, it's just a preference, is if you're wanting me to make rulings about possession and access of children, that should be in a SAPSER. And that's what we're being told. So if you file it into yours, a lot of times you can get better results. A lot of times you can leverage it for a better settlement. And I understand what you're saying about if they're poor, we don't want to charge them more billable hours. But I would think about if it will help your case in the long run. And as I said at the beginning, I am happy to send y'all the forms we use. You know, if the fear is drafting it from scratch, happy to do that. But if that person can't afford the extra however many billable hours, send them to us. The other problem is, you know, for a while we had so many that we were swamped, and that was part of our problem. But
the problem I've run into is historically the judges are suspect when a private attorney files a protective order versus the county attorney. I feel like they, I can't read into a judge's mind, but it's my impression that John have screened it better and that we've just kind of willy-nilly filed something.
interesting.
Yeah, and so it's a problem for us as practitioners.
And it may be something that we have to have an ongoing conversation with and kind of build a policy around, because if that is the case, then absolutely we want these people to be safe. But it's so funny that you say that, because we face the opposite, which is she wants her kids in this protective order, why didn't you file a SAPSER? You know? And so sometimes we just strike kids from our protective orders and say you're going to have to file for divorce if you want the kids in them. So we have the opposite, which is judges look at us and say, you're using this as a tool to bypass a divorce. You're really trying to get me to do possession and access. And so we're seeing the opposite side of that pushback from the judges. And it may be worth seeing if we can open a dialogue with the courts about what they think the best path is.
So I don't mind doing it, but that's historically been the problem I've had.
That's a really great point, and I think I'll make a point to try to look into how the bar would prefer we handle it, because I'm seeing the opposite.
Same thing, I also had a judge deny attorney's fees on a protective order because he told me they could have got to the county attorney's office.
Mm-hmm, know that too.
Well, that is definitely worth looking into. So I will put that on my list to start looking into. I didn't realize y'all were having the opposite. Because they say the same. I think it might be that no matter who files it, there's some skepticism of protective orders. And that may just be one of those things that no matter who files it, people think that it's short-skirting due process and getting them results that should have been done through a divorce. Because we get the same pushback. Oh, there's also a divorce? This is clearly just trying to leverage that. And you know, to me, the code is very clear that these aren't either or protections. You can get both a divorce, a protective order for your child, an EPO, bond conditions. They aren't either or. But I don't know if it's judicial economy concerns or what, but our judges seem to have a very strict idea of what they want to see it in from whom. So it may be worth trying to set up like a bench bar discussion on how they want it handled. Yes, sir.
Do you see, and I'm going to speak from a different perspective, but I know a lot of men that have said that they've actually been victims of domestic violence. Do you see many protective orders filed by men? Or because it seems like your whole presentation is centered on protecting women, but it's one of these things that we don't talk about.
And I should apologize. I use the feminine pronouns because the bulk of what we see are females, but not, you're absolutely right. By no means is it only a female problem. We have applied on behalf of men against other men, and we have applied on behalf of men against women. Domestic violence is not just a one-way street. And, you know, my office will certainly file on behalf of anyone who meets the statutory requirements, regardless of gender, sexual orientation, any of that. I tend to fall on female pronouns because it's the bulk of what we see. And from the numbers I've seen, there's a couple things going on. One is that women are disproportionately victims of domestic violence, and two is when men are victims of domestic violence, there's a social stigma against them reaching out for help. So those two things kind of compound, and most of what we see are female applicants. But I have seen, like I said, I've seen men applying against other men, and I've seen men applying against women. I've seen women applying against women. It is not a one-size-fits-all. But I do think, going back to the social stigma, there's also an issue with police showing up and saying, you're a big, strong man. You can't take care of this. So it's, you know, there are a lot of facets that go into that, but we absolutely do apply on behalf of men. Anyone else?
Is there generally a presumption of guilt when a protective order is filed against somebody, that they almost have to not just, you know, that they don't go through due process, but they have to take like an extra step above to find themselves innocent? I mean, isn't there?
I don't think so.
Okay.
I think it's the opposite. I think that what we were talking about all the time, the sentiment I get is you're filing this to get a leg up in divorce.
Okay.
I think that people generally rely on it as a tactic. And I personally haven't had one denied yet, but our office has had several judges deny protective orders. So I think that they are defensible, and I think the presumption actually goes the other way.
Okay.
Which is that it is seen as kind of a sneaky, subversive thing to get around a divorce.
They're easier to get if you have an EPO in place too.
They are. If you've got an arrest, I
Yeah,
mean, when we
there's
have
an
to pull the
arrest.
guy out of the holding cell to ask for a protective order, then you're fighting an uphill battle to defend them. But if you come in and there's a divorce pending, the presumption's actually the other way, in my experience.